Legal risks loom as California fast-tracks SAF projects under CEQA reform. California's latest legislative push to expedite sustainable aviation fuel SAF infrastructure could face scrutiny over environmental oversight and community protections. As part of its broader climate strategy, the California legislature is advancing AB 839, a bill introduced by Assemblymember Blanca Rubio that allows the governor to certify up to 3 SAF projects for expedited judicial review under the California Environmental Quality Act, CEQA. While the bill aims to accelerate decarbonization in the aviation sector, critics warn the measure could set off legal disputes over due process and public health safeguards. The CEQA trade-off: speed versus scrutiny. At its core, AB 839 amends sections 21189.81 through 21189.83 of the Public Resources Code to include SAF infrastructure as a qualifying project for CEQA streamlining. These projects would benefit from a 270-day limit for courts to resolve legal challenges, concurrent preparation of environmental records with EIR review, fast-tracked litigation procedures, including optional use of a special master, and no judicial review of the governor's decision to certify a project. While designed to reduce uncertainty for investors and developers, legal experts suggest this accelerated timeline may erode the public's ability to meaningfully engage in environmental oversight. Precedent and pushback. California has previously faced legal pushback for fast-tracking CEQA review of controversial projects, notably during the development of large-scale sports stadiums and high-speed rail. Although AB 839 applies only to a limited number of SAF projects, stakeholders from environmental justice communities are watching closely. Communities already burdened by poor air quality, especially near airports and refinery zones, deserve full transparency and a robust environmental review, said a representative from a regional clean air coalition who asked to remain anonymous due to ongoing negotiations. The bill attempts to mitigate concerns by requiring no use of fossil fuels in production, reduced emissions for conversions of existing tidal fee sources, and impact mitigation specifically benefiting disadvantaged communities. However, opponents argue these provisions may be insufficient without full CEQA litigation timelines. The stakes: SAF's role in California's climate goals. California has ambitious aviation decarbonization targets. Under CARB's 2022 scoping plan, 80% of interstate commercial aviation fuel must be SAF by 2045, totaling an estimated 3.5 billion gallons. Current SAF production, by contrast, remains limited both in scale and geographic distribution. Proponents of AB 839 argue that CEQA streamlining is essential to meet these deadlines. The bill's legislative findings cite urgent climate threats, wildfires, extreme heat, and emissions from hard-to-electrify sectors as justification for prioritized review. Without accelerated permitting, SAF proponents say California risks falling behind other states and losing private investment to less regulatory-heavy jurisdictions. Legal uncertainty ahead? As of July 8th, AB 839 remains in Senate committee, with its first hearing delayed at the author's request. Whether that signals a cooling of momentum or strategic recalibration remains unclear. What is certain: if the bill passes and projects begin moving forward under expedited review, legal challenges are likely, particularly over CEQA's long-standing role in environmental protection and public participation. With the aviation industry eyeing SAF as the only viable near-term solution to reduce flight-related emissions, California now faces a familiar tension: balancing urgency in infrastructure development with equity and environmental integrity. You've been listening to Sustainability Soundbites from E+E Leader, where the business of sustainability meets real-world impact. With over 10,000 downloads and 23,000 views on YouTube, your brand could be the next to lead the conversation.